All right, the court is calling Tommy Lopez. And counsel, you can explain that to him about the retention of the jurisdiction.
I will, Judge.
Thank you. Who's here for Tommy Lopez?
I'll be here, Your Honor.
Thank you. How's it going?
Good, how are you?
All right. Court is calling 2024 CR 011089 State versus Tommy Lopez Jr. Could I have parties announced for the record for the state?
Ashley Jones?
Defense?
Adam Flores, Your Honor.
And are there any applications in this case?
No, Your Honor.
State, are you proceeding on the indictment as presented?
We are not, Your Honor. We are waiving the habitual enhancement allegation.
Any objection?
No objection, Your Honor.
Do you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the prison. There's a $1,500 fine, affirmative finding of deadly weapon. There are no applications. The state will take in consideration 2024 PF 10226. There's to be no contact with the complainant, and you are to agree to a civil protective order at the Justice Center. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor. On the protective order, it'd be for the time he's serving in prison. 2 years, I believe.
I'm not in charge of when he is to serve his time as it relates to the protective order. I'm just here to tell you, a part of your plea bargain agreement is he's to agree to the civil protective order. So has he already agreed to that?
Yes, Your Honor.
I'm sorry, Judge. My understanding, yes, is that he has agreed to it. Our complainant is going to be applying. And so there is a process that it goes along with that.
All right, so when you serve that, that is not under this court's jurisdiction. Do you understand?
Mhm.
Did you, that's yes or no? Yes or no?
Yes, ma'am.
All right, did you understand that to be the entirety of your plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Then to the offense, how do you plea?
Guilty.
Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
He takes responsibility, Your Honor, for his actions, Your Honor.
All right, what is, because this complainant came to, I guess, a homeless location to give his mother food. What is the mother's name?
Nora Vital.
I'm sorry, what?
Nora Vital.
You say Vital?
Mhm.
Vital?
Yeah.
And the first name Nora?
Nora.
All right, so why did this escalate to this point if he's just there to drop off food?
He just started on me. He
No.
wanted to file on me.
No, what it says is the victim's son stated that the victim was there to drop off food to his mother, who is homeless. Victim stated he got into an argument with mom's boyfriend and his mother, which then escalated to the suspect repeatedly swinging a machete at him while chasing him. Victim stated that he picked up a skateboard nearby and used it to protect himself from being struck. So according to this, he's just there to give food to his mom who's
We
homeless.
were in the park. We had a barbecue. We were in the park. We were gonna do a barbecue.
So you're saying you're not homeless?
At the time, we were homeless.
All right, so you're saying all of this is not true, and the collection of one glass pipe that's in the police report, you're saying that's not true?
Well, Your Honor, he's pleading guilty because it's the best thing for his case, Your Honor.
Yeah.
The complaint gave a contradictory statement to the DA. Well, he's willing to plead guilty to get the case over with, Your Honor.
All right, court is going to find you guilty, sentence you to 2 years in the prison, give you credit for any time served. There's a $1,500 fine, time and money run concurrent. Take in consideration 2024 PF 10226. There's an affirmative finding of deadly weapon. There's to be no contact with John DeLeon. You agree to a civil protective order in the Family Justice Center. The court will note for the record that the defendant has previously agreed to that, and there's to be no contact with Nora Vital. All right, good luck to you.
Thank you, Your Honor.
You're welcome.
Maybe excuse, Your Honor.
Yes.
Thank you, Your Honor.
Who's here on Christina Martinez?
This is a motion for a competency evaluation.
All right. Then, Ms. Ferguson? On this, I need to reset up for a competency evaluation. And where is Christina Martinez? Okay. All right, so attorneys, you all are not ready if your client is not in the box. All right, Christina Martinez. Hello. Hi, what date? All right, your attorney is requesting that you see a doctor. So we're going to bring you back on March 6th.
So I have to say.
Well, have you had a chance to speak with him today?
No, I didn't get the chance to talk to him.
We talked some time ago, and it was, may I ask the court's procedure? Will the court go ahead and order testing at this point, or we do that on March?
Oh, no, you will go to the magistrate's court to have the testing done, and
I
you'll go
didn't
to
know
have
that.
this order heard.
Thank you, Your Honor.
All right,
I'll talk to her now.
okay. All right. Who's here on Ezekiel Martinez?
I am, Your Honor.
Hi. I just noticed you guys. I have tunnel vision. Where are the babies? Oh, they're there? Oh, wow. Okay, I'm gonna have to step down to see them. Yes.
So I just got appointed to him today and he wants a trial, a jury trial.
All right. And I'm assuming you're not ready for trial today.
I'm not ready. for
All
trial
right.
today.
Mr. Ezekiel Martinez? All right, if you can step down. All right, Mr. Martinez, it's the court's understanding you're requesting a jury trial?
Yeah.
Oh, I see he's tired. You know, they say when you yawn, if other people yawn with you, that means that they care greatly for you. Just throwing that out
Like
there.
a ripple effect.
Yeah, and you know, I found it to be true. So, Mr. Martinez, state, were you able to tender an offer to him? All right, so you're rejecting the state's offer?
What was that? Yeah,
Do you, here's the thing. I need you to be 100% focused, okay?
yes, sir.
Because this is a serious thing. You're charged with evading arrest detention with a previous conviction. The state has tendered you an offer. Do you understand what that offer is?
Yeah,
That's yes or no?
yes.
All right. So do you need time to think about that offer, or do you want a jury trial?
How much time do I get to think about it?
I can call you back on Thursday.
Okay, yeah, I think about it.
Are you available?
Thursday would be good because then I can review the videos and
All right. So Norma, if you recall this for Thursday, February 6th.
well, yeah, February 6th, I'll be here. Yeah.
All right.
I leave in the afternoon.
All right. So that will be your plea deadline date.
Okay,
All right. Thank you.
okay. So I'll see you here on Thursday.
Thank you.
Okay.
Okay.
I can come to your phone?
Do you have phone access?
Yeah.
Yeah, you can call me. Or I'll zoom in with you. I'll order you to zoom in. Okay?
All right. Michael Gonzalez. Hello. Hi. All right. So where are we on this case?
He was just recently indicted, Your Honor. We still need to go over discovery.
All right. And I'm assuming there is maybe a plethora of discovery.
Correct.
Yeah, I think so.
Yes.
All right. Ms. Ferguson, if I can have a 45-day reset on Gonzalez.
Thank you, Judge.
You're welcome. And it's discovery.
Thank you, Judge.
All right, March 20th.
Thank you, ma'am. Judge.
Excused?
Yes. Gabriel Diaz.
Hi, Judge. Good morning.
Hello. Where's Gabriel Diaz?
Well, that's the question now, isn't it, Judge? So Norma suggested that I approach you to figure out how you want to handle it. I have my receptionist reaching out to him to find out, is he planning on joining us today?
All
Just
right.
to find out if you want to recall us at 1:30 or you
Yes, we
just
can
want to
come back
call
at
the bond
1:30.
forfeiture, whichever you.
No, what do you prefer?
I have other settings to get to.
All right. All right, Court, Deputy Laura, can you, make an announcement for Gabriel Diaz? Court is calling 2024 CR 010128, 2024 CR 010131, 2024 CR 010149, State versus Gabriel Diaz. Can I have parties announced for the record for the state?
And Harris Edelman.
Defense?
Carl Alexander for Mr. Diaz.
All right, this hearing was scheduled at 9 a.m. It is now 11:37 a.m. The defendant has not answered docket call. Deputy Laura, did you make an announcement in the hallway?
Yes, Your Honor. Did he is now.
All right, defense, do you have any contact with your client?
Judge, and I was checking my phone when you were calling the case. I apologize for that because I was texting my receptionist. So she did, as per our procedure, reach out to him last week, notify him, remind him of the court date. She tried again this morning after I arrived and realized he wasn't here. And as of during today, we do not have any contact.
All right, state, your request in each case?
Forfeit the bond, issue a warrant.
All right, in each cause number, the court will grant the state's motion for a bond forfeiture. In each cause number, your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
May be excused.
Yes. Jesse Arriaga. Good morning.
We're actually set for trial tomorrow.
Yes.
Ashley had wanted to approach this morning, although I thought. I think she just wanted us to advise the court that we were going to accept the new offer they just made.
Okay.
Because she wanted to be able to not have to call witnesses and get ready. I think she just wanted to put me on the spot
All right, sure.
to do that. And of course,
Okay.
she's not here to see that I did that.
All right, so,
But he did for a plea issue.
all right, so that'll be done tomorrow then.
Yes.
All right, thank you. Robert Castillo? Yes.
I've got two motions that I wanted to present to the court. We've got a trial date. I think it's trial date, either that or a last,
March 4th.
March 4th.
Yes.
And so, I had the first motion I've got is our third motion for access to the vehicle and for a motion to appoint our expert Gregory Pratt. He is former FBI. He was on the ERT for Sutherland Springs as well as Fort Hood.
Oh, well, you can have whatever expert you want to have. So,
So what we're looking for is actual bullet slugs and bullets. The second motion that we have is I received a notice through e-discovery that the state had filed a search warrant to remove the bumper from that Tesla.
Mhm.
And I've got several requests regarding that. First, if that has not been signed, that the court would deny that warrant.
all right, so here's the thing. One, I don't know if it's been signed or not. Number two, it sounds as though that this needs to be set for a hearing.
Okay.
So if y'all will come back to the tomorrow, the court will hear it. And if y'all will confirm motions, because this is off docket.
It is
Yeah,
a
Judge,
docket,
and
Judge.
had counsel, I conferred with me, I mean, the search warrant has already been executed and it goes to what he's alleging, so I don't really anticipate that it would be an issue, but I will speak with him.
I'm happy to confer, Judge.
All right,
Absolutely.
and then your client will need to be here. Is your
Right.
client in custody or on bond?
He's on bond, Judge. Could we set that for Thursday? Is that a possibility?
You have to speak to the coordinator because it depends on our trial setting.
Understand, Judge.
All right,
Thank you.
you're welcome. All right, Oviedo? Yes. I'm sorry. Oh, just give me 1 second. Okay, no problem. Oviedo? If you'll come down, where are we on this case?
We would like to reset it in 2 weeks. I just actually got notice of today's hearing last Friday,
Okay,
but I think we probably have a plea worked out. But I've got to check out something, so we just need 2 weeks if we could.
all right, Ms. Ferguson, if you can recall this in 2 weeks, please. I think that puts us at February 18th. All right, February 18th. Thank you.
I'll be back this afternoon if you make it.
All right, thank you.
Thank you, Your Honor.
You're welcome. All right, Christine Brown. Hello, hi. Well, I saw your case is being set for a motion to suppress today. Ms. Ferguson, is there a reason why her attorney is not here?
Martinez Ezekiel. Martinez, Christina. Jaime Lopez, Michael Gonzalez.
We're trying to, have you had contact with your attorney?
No, ma'am.
But we're here on Brown for a motion to suppress.
Your Honor, may I address the court?
Yes.
I requested the officer who received what is believed to have been the consent search from Ms. Brown. That officer is not coming in for today's hearing, so if the court will allow me, I'll file a motion to dismiss for missing witness.
All right, thank you so much.
If you'll
So-
excuse me.
Yes. So do you want to wait for your attorney or do you want the dismissal?
Dismissal, please.
Yes,
Thank you.
you're welcome. So how are you doing today?
I'm doing fine, thank you.
I better today,
Yes,
right?
ma'am.
Thank you for dressing appropriate for court. All right, so if you, he's doing the dismissal now. If you'll just have a seat and I'll get that to you.
Thank you.
You're welcome. All right, we're still waiting on that, so. Hi, guys. Oh, can you guys bring the babies up? I'm sorry, I didn't Yes, you can. Maybe that'll bring people down, but they're great. So they usually come to help children who are testifying. And adults. And adults. And yours. And yours. You want blue? Yes. See, she knows, right?
She did. Everybody else.
Come here, just some love.
Hi, great. Saturday looks so good.
Oh,
It's over here. I know, the next one I'll have to, they're right here and then I'll put it down to her right here. I'll go sit. There you go.
Oh, baby girls. And boys.
boy.
Come on in, Bashan, come on in.
Get in there, get in there. Here, give me your phone.
Come on in, stay.
There you go.
Sit.
Right in there.
Coco.
Turn around. Sit on this way.
Sit.
It's okay.
Oh, Coco's like, no, not today.
She's gotta sit sideways in front. No, Piper, look, Piper.
Piper's doing her own thing. Okay, and can I tell you, they're so strong.
Wait. Look, bless you. Okay, wait. Wait, Piper, look.
But thank you guys so much for all you do to help children out.
And adults.
And adults, we need this
And the
today.
juror, yes.
And the
the juror,
jurors.
that's the thing. So yeah, we'll be swinging by every now and then. Call me, let me know, and we'll be here. And, yeah, we'll make sure that.
Oh, I appreciate it. Thank you so much.
For
Bye,
going
baby
to.
girl.
I can put her at your feet, you can just rub on them.
Oh, see, okay, we need that,
There
right?
you go, you'll be rubbing your feet, right? Sit. Oh, that's it. Okay. I know, right?
So guys, I don't think we're gonna get anything else done. But they, the level was here, they take it.
Oh, yeah.
That's why we bring them.
Oh, they're so awesome.
Even you, so if you're stressed out, just let us know, we'll come here and love on you and be there for you and.
Oh, awesome. Thank you so much.
That's being paid, we're being paid with it, actually.
Yes.
So this is easier.
Oh, awesome. Well, in this part, we're all dog lovers and pet lovers.
Oh, yes. So, yeah, so
That's how we
they're
tell
they're
people
behaving.
we're
That's so awesome. Right? I will see you. All right, thank you so much. Let me know the next event. I will be there. Okay, awesome. Saturday was just so crazy for me.
And they'll let you know if you have child witnesses or anything.
Yeah. When it comes to the drink, is our last one over here? So we see the jury, so whenever they go back to the jury room, we're gonna talk about the last.
I will let them know if there's issues where the jurors want something.
Relaxing, exactly. He's one of the good ones. He's a good boy. He's a fun.
You're on
Yes, thank you guys so much. And they feel so great, right? All right, Mr. Pettis, if you'll come down. All right, Deputy Lord, now everybody is relaxed. We've decompressed.
I don't know what you're talking about.
All right, so today is plea deadline date.
Yes, Your Honor. We're going to trial for sure. My only problem is they drilled 4 holes in my teeth and made me wear a denture so the rest of my mouth doesn't swell. As the court can tell, my speech is not all that well right.
All right.
So just, we would like that. He wants it quickly, but I probably need a couple of weeks to at least speak right.
All right. Have you talked to the state and considered a bench trial, or do you want a jury trial?
I would like a jury trial, and we did negotiate on 2 occasions for possible plea bargains. We haven't been able to do that.
Do you want a bench trial or a jury trial?
I don't know what's the difference now.
All right, a jury trial is where 12 people will be sitting in the box. Witnesses will be questioned. And the jury will make a decision if they can come to a decision on whether you're guilty or not guilty. A bench trial is where I listen to evidence that is presented and I make a decision on whether you're guilty or not guilty. What I can tell you is I've had bench trials in this court before. Some people I found not guilty, some people I found guilty. What I can inform you of is the state, if the state proves their case beyond a reasonable doubt, you're going to be found guilty. If the state is unable to prove their case beyond a reasonable doubt, you will be found not guilty by the court. I just listen to the evidence and I make a decision based upon the evidence that I hear. You understand?
Yes, ma'am.
So, do you understand the difference between a bench trial and a jury trial?
Yes, ma'am.
All right, do you want a jury trial or a bench trial?
A jury trial.
All right, Ms. Ferguson, recall this in 2 weeks for jury trial, please. It should be a short trial. Am I correct, State?
3 days.
Yes, it's 3 days.
Okay. All
right, February 10th is your jury trial date.
February 10th. Thank you, Your Honor.
You're welcome.
Thank you, ma'am.
For helping me with.
You're welcome. They'll bring you back over dressed for trial in whatever clothing you have at the jail. If you wish to be attired in something different, you have to do a clothing exchange with your attorney. Do you understand?
Yes, ma'am.
All right, thank you.
Thanks.
Who's here on McIntyre? You all ready?
Your Honor, we're ready to proceed.
Court is calling. Everyone needs to be quiet. Court is calling 2019 CR 12495 State versus Tamar McIntyre. Can I have parties announced for the record for the state?
Jason Garringham, Your Honor.
For the defense?
John Hunter for Mr. McIntyre, Your Honor. I believe that
Where is he?
Mr. Goldstein is.
Yes, he is. He's here.
Good morning, Your Honor.
Good morning. All right, this is scheduled for jury selection on Friday. Why are you all here? What motions do you have?
The state filed just a motion on limine, Your Honor, just for a few things. I don't know. It was filed this morning, so I don't know if defense has had an opportunity to view it.
I've not received service of it, Your Honor. Mr. Goldstein advised me just by telephone about 2 minutes ago that he saw that it had been filed, but I don't believe he's read it either.
All right, so
I was unable to open it, Your Honor, and my apologies.
No problem. With regards to motions and limines, I do not know anything about this case. So as far as me ruling on any motion in limines, unless it's something that's specifically in case law where it's not allowed, then of course the court will make its ruling. But if it has to do with whether or not certain questions should be asked or whether or not certain evidence should be presented, y'all will need to approach prior to going into whatever subject matter you have with regards to motion in limines from the defense or from the state.
And Judge, it's not something associated with voir dire, it'd be associated with the actual case in chief and punishment, so it's not a question of hearing it before we pick a jury.
All right. Any other-
Your Honor, if I may, I'm particularly concerned about a recent disclosure that the state's key witness has given prior sworn testimony before a previous judge in this court regarding our client's her and our client's participation in this case. And I believe I would like to make sure that we're able to supplement our motion for continuance with state versus.
Just one second. Let me finish addressing the state. Are there any other motions?
Not at this moment, no, Your Honor.
All right, defense, any motions?
Your Honor, we filed a motion for continuance back on January 24th, and I informally had advised the court of the fact that that was a concern. Let me update the court since then, because there will be need for us to supplement.
All right, and
because of its
before
verification.
everybody updates me on the supplemental as it relates to the motion for continuance, let me ask everybody a question. Did I not ask you all what date you all wanted for jury trial? I had given everybody continuances before. People wanted to go on vacation or trips with their family members. I let them go. I said, talk to the coordinator and choose a jury trial date. Is my memory faulty, or is that what I did?
Your Honor, let me, if I could give.
Well, no, we're gonna get to that. But did I do that?
Yes, Your Honor.
Did you all choose this date as your jury trial date?
Yes, sir.
Did
Yes.
you all choose Friday as the date for jury selection?
Yeah, yes, sir.
All right, and then today was supposed to be for motions. And this was done, I think, back in November. So before I get into your motion for continuance, because I want the record to be clear, this case has been on the court's docket since 2023. We are now in 2025. So May 8th, 2023, this case was set for discovery. It was called back on June 5th, 2023 for discovery. Then it was called back on August 3rd, 2023 for discovery. Then it was called back on October 5th, 2023 for discovery. Then it was recalled on December 7th, 2023 for discovery. Then it was called on January 30th, 2024 for discovery. Then it was set for jury trial. And it did not go to jury trial because there was more discovery. So then we came back on April 2nd, 2024, and it was set for jury trial for October 14th, 2024. Then everybody said, we can't do that. We have vacation, we have this. Then we came back on September 19th. I'm sorry, we were here on April 2nd, 2024. Then we came back on August 27th, 2024. Then it was recalled for September 19th, 2024. Then it was recalled for September 23rd, 2024. Then it was recalled for October 10th, 2024. Then we had the jury trial scheduled for October 14th, 2024. Then we came back on November 21st, 2024, discovery acknowledgement sign. And then we came back on December 2nd, 2024. I told both parties I wouldn't charge a continuance to either side. Then we came back and here we are. So I'd like the record to be clear on what is happening in the case. So now I'll hear your motion for continuance.
Yes, Your Honor. With respect to the court's recitation of the history, I think it's important that we make clear the settings that were held in September of 2024, we had every reason to believe when they were being discussed in the spring of 2024 would hold based upon the production that the defense had already received and based upon the state's representation that apart from jail correspondence, which was of little evidentiary value in the case, no additional discovery would be forthcoming. In July of 2024, the defense, in getting ready for that trial setting and making preparations, found a one-line entry on one page of what is otherwise a very extensive and copious amount of paper discovery, referencing a remark by a detective that he wished that he could also have in his possession ballistics reports done on a firearm that was recovered from Jalen Bell, who is an indicted co-defendant in the case, who has already pleaded guilty and been sentenced to prison. We, based on the discovery, came to the conclusion that no such firearm had ever been tested, and that its origin, or its location at that given moment was unknown. We began conferring with Jason Garahan for the state about this matter, and we tried to bring this matter to the court's attention. Mr. Garahan engaged.
Wait a minute. Let me stop you right there. What do you mean you tried to bring it to the court's attention?
We informally approached the court, I believe, on a couple of different occasions to advise that this was a matter of concern, and then eventually we filed.
Are you talking about
motions.
when you filed the motion for continuance?
The original motion for continuance was not the first time that we had made the court aware of the issue, is what I'm trying to avert to. We were concerned almost immediately in late July, early August of 2024, that this was going to be a matter of concern, and we were trying to get to the bottom of what was going on.
But you all picked the court date
Your Honor,
for the jury trial.
Yes, and as I'm explaining, that court date was selected sometime long ago. In the course of preparation for that, we found a very, very, very small reference to this firearm in what is otherwise a very, very large amount of evidence. We advised the prosecution of that fact and sent over a draft motion to compel about anything that was related to it. But of course, we didn't need to file or urge the motion to compel because Mr. Garahan, who has been doing an excellent job keeping up with this, was similarly, I believe, and correct me if I'm wrong, not really aware of the firearm recovered from Jalen Bell because previously it had had such little significance.
So you didn't file a motion with the court urging the court to compel any evidence, correct?
We approached the court and advised the court of the fact that we were trying to sort out this discovery matter between the parties, which we did. We sent a draft motion to compel over to the prosecutor, and rather than having to urge it formally to get an order for the production, the prosecutor undertook his own independent steps to locate that firearm.
All right, so I'm just trying to get the record to be clear, because I like for the record to be clear.
I'm doing my
Nothing was urged with the court. No motions were given to the court about any other evidence, correct?
Well, in September, Your Honor, I believe we did urge a reset or a continuance based upon this information. But I'm just giving the backstory to the time when we formally discussed resetting the case because of it was not the first time that we had brought it to the court's attention that we were concerned it might cause delays in the process. And I'm further just trying to explain that this wasn't evidence that the prosecutor just had in hand and it was in his file and he just hadn't given it to us. It was information that Mr. Garahan similarly did not have anything more than we did about it at the time that we corresponded. Now, law enforcement involved in the case may have, but it hadn't made its way over to the DA's office with the rest of the discovery.
So that's September, October, November, December, January?
I'm not quite done with the recitation, Your Honor. I do want the record to be clear.
Sure.
So we advised Mr. Garahan of this throughout August and September. Efforts were made to locate this. The prosecutor advised that they had identified the firearm that we were discussing, and they sent it over for ballistics testing. That ballistics testing came at the end of September in accordance with when the court reset this matter for this issue. We engaged an expert witness at Huskey to conduct his own independent analysis of the firearm. Mr. Huskey advised he would not need a laboratory of his own to conduct that analysis, that he could work off of the bench notes from the firearms investigator for the state of Texas. My records indicate that we engaged Mr. Huskey formally on the 10th of October, but we would have been in discussions with him the week prior. We have sent Mr. Huskey, we believe, everything that he needs to complete his analysis, but Mr. Huskey has advised that he has not finished his analysis. This was the major pressing concern of the remaining settings of the fall, is that we did not have the ballistics analysis. And we believe that this is an extremely material piece of evidence because it goes to the heart of the state's case, which is that Mr. McIntyre was the shooter in this engagement, and that there are at least, there are 4 other individuals in the car besides the deceased. So, and the deceased, just to give a brief summary of the facts, the police that have investigated this have averred that the deceased was ejected from the vehicle or forced out of the vehicle, that he jumped back onto the hood of the vehicle, and that they allege Mr. McIntyre discharged a firearm and killed him. So if, in fact, that firearm that was in the possession of Jalen Bell were to be identified as the firearm, or if it could not be ruled out as the firearm, that would be a material aspect of Mr. McIntyre's defense and an essential one. So that explains the general landscape. Yes, along the way, there were discussions about scheduling conflicts, some of them of a personal nature with some of the litigants. But the primary thrust and reason why we have been resetting this matter time and again since September has been out of concern for the fact that the defense has been unable to
No,
independently
this has
vet.
been reset since May of 2023.
Yes, Your Honor, and I'm just explaining, we did not discover this information until the time frame that I am letting the court know about. We discovered it at the end of July. Throughout the course of August, we were conferring with the prosecution. In September, we had discussions at the bench about this matter on the record, in which it was established that we needed this information, that it was material. The court granted the continuance on that basis. The state was able to produce for us a ballistics report for this firearm. That ballistics report required us to have to go and independently vet whether the report was accurate or if there were any reasons that we might be able to cross-examine the author of the report based upon his analysis. And that's what we have been working very diligently to try and accomplish, but we don't have that report yet. In the interim period, at this court's last setting in December, the court asked if discovery had otherwise been fully complied with, and we believe it had, apart from this continuing issue that we've experienced regarding Mr. McIntyre's jail correspondence, which we've now discovered the reason why we've been unable to download that material is because an associate in Mr. Goldstein's office, who's only made one filing in the entire case, has mistakenly been placed on the clerk's list as the lead counsel. And as a result of that, neither I nor Mr. Goldstein were able to access from our credentials that e-discovery. However, Mr. Garahan has been extremely helpful with us because the state didn't realize why we weren't getting the discovery either until just a couple of weeks ago. And we have been going over and meticulously getting this information on external hard drives and hand it over to us so that we can process it. It's voluminous, but it is largely not relevant to the litigation. At that setting, the court asked of the state of Texas whether or not it had fully complied with Article 3914, and both parties represented that we believe that it had. Since that time period and since the first of this year, and we've
Just 1 second, let me go back to this expert. According to our last hearing on October 10th, 2024, the information I received from both parties was this. I said neither side would be charged with a continuance. State was unable to have some witnesses appear because of the county budget. You requested a testing of the weapon. So everybody knew about this weapon. And I said that both parties have been diligent on doing this. And then the defense was to file a motion to allow for testing of the weapon, which I'm assuming you did and the court signed.
We didn't need to, Your Honor, because
Well,
our
well,
expert advised he didn't need it.
And then it says defense expert has no lab, will seek outside lab or state lab for testing. So you all had this information, unless there's a different gun, everybody had this information from October 10th.
That's what I'm explaining, is that by October 10th, I mean, so we discovered there was a problem in end of July, beginning of August. Throughout August, we were looking for a gun. By the September settings, we were aware that there was a gun.
Yes.
And then the state produced a report. On the 10th was the date that we had engaged formally Mr. Huskey, having conferred with him informally for a week prior. We weren't even sure if we would be designating him as an expert at that time. We, at the time that we had that bench conference, assumed, not being firearms experts ourselves, that it would require Mr. Huskey to have access to the physical weapon and to the laboratory analysis. Mr. Huskey has advised us, and I believe that this is consistent with what I've later learned talking to other people in the field, that it is very common in the industry of firearms and tool mark examination for the examiner to be able to run a preliminary round of review and critique of the methodology and the reliability of the data based solely on the bench notes and the work product of the original firearms investigator, and that we would not need access to a laboratory. That led me to have an overinflated sense of how quickly we might be able to get it done if it was simply a matter of paper review. But it has turned out that that doesn't seem to be the case, and Mr. Huskey has not, as of today's date, given me a final report that I would be able to make use of. In fact, I'm having to essentially designate him somewhat prematurely because I don't have an opinion upon which I can confidently say that I would choose
Have
to
you
call.
called him to ask him
Multiple
when he's
times.
available?
Multiple
Well,
times.
what's the answer?
Well, he's physically available for the trial, but he doesn't have any
When will he
analysis.
have analysis done?
He hasn't given me a straight answer.
Well, you need to call him and ask, because this case is not going to be sitting out here forever. And this is the court's problem. My problem is everybody comes in here and wants a special setting for trial. I give you a special setting for trial, and then at the last minute, the week before trial, people are not ready. People want 200 jurors brought down, and then all of a sudden, we need a continuance. So we're going to stop this hearing. We're going to go in recess on this hearing. You're going to call him, and you're going to find out when he's going to have it done.
Yes, Your Honor. But before we stop the hearing.
No, we're going to stop it now because you need to call him and find out when it's going to be done. Because I need to know if he's going to have it done in 2 years or 3 years. We'll pick this up where you left off, but that's the number one question for the court. When is it going to be done?
I will report back.
All right, thank you.
Your Honor, may I be heard on about one matter?
Yes.
Thank you, Your Honor. Additionally, this past week, we were advised that the state's chief witness has actually testified under oath, and that's what I was trying to address. The Court of Criminal Appeals, in a recent decision from last June, held that the transcript of such a testimony is discoverable as soon as is practicable. We've been asking for this kind of stuff for years.
All right, so this is what I need though, Attorney Goldstein. I need to know when your expert is saying he's going to be done with this.
I understand, but we also need the transcript of that testimony because the Court of Criminal Appeals has been very clear. We can't be compelled to try the case if a chief witness has given prior sworn testimony about the same matter.
I understand what your attorney is saying, Attorney Goldstein, but what I'm telling everyone, I want to know when your expert says he is going to be done with his analysis. So that's what I need to know right now.
Thank you. We'll get on that and be right back with you on the record in just a moment.
All right, thank you.
Thank you for your patience, Your Honor.
Oh, no problem. All right, we're back on the record in 2019 CR 12495 State versus Tamar McIntyre. Could I have parties re-announced for the record for the state?
Jason Garahan, Your Honor.
For the defense?
John Hunter and Jerry Goldstein for Mr. McIntyre.
Good morning, Your Honor.
Good morning.
Your Honor, per the court's request, I have called Mr. Huskey to ask him when he might have a report for us, and he advised that he should have a report ready for us in 30 days.
All right, the good old 30 days. All right, and let me do this because the record really was unclear as far as the court's rendition of the timeline, because the document that I was looking at was not the murder case. It was on the docket sheet, was from the
controlled substance case?
Yes, the controlled substance. So let me read into the record the times that this case has been in this court. And actually, this case started in 2019. So December 19th, 2019, there was a pretrial hearing. That hearing, we came back on March 3rd, we came back on April 27th, 2020. Then we came back on March 3rd, 2021.
Your Honor, I'm so sorry to interrupt, but I want to make sure that the court has the timeline accurate because there's a couple of problems. The first being that this case was originally filed as a juvenile matter. Because Mr. McIntyre was certified an adult in Fort Worth, that became a foregone.
Yeah, I understand that. So I'm reading what's on this document, just reading it into the record. So December 19th, 2019, there was a pretrial and it came back on March 3rd, 2021. Then it was recalled for April 21st, 2021. Then it came back on June 17th, 2021. Then it came back on August 10th, 2021. Then it came back on January 13th, 2022. Then it came back on October 26th, 2022. Then it came back on December 6th, 2022. Then it to this court, and when it came to this court, it came on May 8th, 2023. And then it was retained attorney, and it came back on June 5th, 2023. Then there's discovery on August 3rd, 2023. Then there's discovery hearing on October 6th, 2023. Then there was discovery hearing on December 7th, 2023. Then it was recalled for January 30th, 2024. Then it came back on February 22nd, 2024. Then it came back on March 11th, 2024. Then it came back on April 2nd, 2024. It was set for jury trial in the central jury room on October 11th, 2024. And I bring that setting up because that is a special call for jurors. And the jurors are paid, I believe, approximately $75 per juror. And both, well, I won't say both, but there was a request for 200 jurors to be brought up on that day. And testimony was to begin on October 14th. That did not happen. So we came back on August 27th. Then it was recalled for September 19th, 2024. And then it was recalled for September 23rd, 2024. Then it was recalled for October 10th, 2024. Then it was recalled for November 14th, 2024. Then it was recalled for November 18th, 2024. Then I'm sorry, just one moment. Strike that last one. It wasn't November 14th. Then it was recalled for November 21st, 2024. And then it was recalled for December 2nd, 2024. And then it was recalled for November 21st, 2024. And that's when all parties chose jury selection, again, in the central jury room for 200 jurors at $75 per juror, which the taxpayers are paying. And we were supposed to be having jury selection on Friday, February 7th. So with regards to your person, you're saying 30 days?
Mr. Huskey advises that he can give us an opinion by 30 days from today's date, Your Honor. Yes. That's the first major point of concern in our motion for continuance. The next point of concern is actually something that I did not learn of until yesterday evening. When the co-defendant was pled way back, like in 2017 or 18, it was my understanding that there was a sealed plea agreement that was entered into for that. The state has disclosed the contents of that agreement, and that's not the issue. What I learned of last night is that it appears that when the plea was received by Your Honor's predecessor on this bench, the prosecution put the co-defendant on the witness stand and elicited substantive evidentiary testimony from the witness about Mr. McIntyre's involvement in this shooting as a condition of the plea agreement, or as, I guess, sort of a memorialization of the testimony that she had promised to give pursuant to the plea agreement. We have not received any such transcript, and I never thought to examine that because, as the court's well aware, a substantive testimonial rendition of the factual basis of the plea is very seldom entered into in state court in Texas. And so it was of no value to us to pull a colloquy of, is this a voluntary plea agreement, or those kinds of things. But it appears that there is substantive testimony of the witness that has not been produced. I advised Mr. Garahan of that issue this morning, and he is similarly unaware of such a transcript, but it is something that we would absolutely need, and we have a right to under 3914.
And by the way, Your Honor, the motion under 3914 and the letters that are a matter of record requested any such statements back some 3 or 4 years ago, anyway.
So that's another major point of concern. in addition to that point of concern, since the new year, since January, and since it was last represented to the court that the discovery process had completed itself, the state has turned over a large quantity of additional material, which I've outlined by bullet point in our sworn motion for continuance. Some of which is unimportant, but some of which is substantively significant, including statements from indicted and convicted co-defendants. None of which I've had an opportunity to review because I've been defending another murder case up until last Friday. Additionally to that, when I first informally approached Your Honor back on the 24th of January to advise the court of this concern, I was advised by the prosecution that there has been a reworking of an old phone dump that previously didn't have a whole lot of substantive value to the case that needed to be turned over and was turned over. We've received a flash drive or an external hard drive with the contents of that phone. This is a phone that was recovered from the Kia, which is the vehicle where this incident is alleged to have taken place.
All right, so this is what appears to the court. It appears to the court that this is one of those cases because obviously people are not reading things, that this needs to be brought back every day for you all to decide if you all have discovery. And I will tell you this, I'll grant your motion for continuance. Jury selection will not take place in the jury room. There will not be 200 jurors called up. You're going to be in this courtroom and it's going to be, I think, Deputy Laura, how many jurors fit in this courtroom? It will be 75 jurors. That's what's going to happen. There will be no other special settings. Do not ask for a special setting. Do not come to the court saying the room is too tight, because this is what you're dealing with, because this will be the second continuance where 75 jurors were called up. And 200 jurors were called up and they're paid $75 a juror. That's the taxpayers that pay that. And then people, I believe you came and said, well, can't we just use those jurors for other courts? No, because nobody calls up jurors on Friday. Those jurors are called up and they're paid. And they're paid for Friday. So do not come back to this court asking for the central jury room. That will not be done. The end on that subject matter. With regards to this witness who testified, this co-defendant, State, do you know who the co-defendant is?
My understanding is, I did speak with Mr. Hunter off the record, Your Honor, and I was just brought to my attention that allegedly that this individual, and I do know the individual that is named, that he gave me the name, apparently got on the stand through what Mr. Hunter mentioned to me and was questioned by the judge at the time, I believe Joey Contreras, and also the prosecutor, Jason Goss. I know that she had defense counsel with her. I don't know if there was questioning through that individual. So I just became aware of that literally probably about 10 minutes ago. We'll do our due diligence to look into that. But again, I just became aware of that through defense counsel just about 10 minutes ago.
All right, well, you all need to find the court reporter, whoever that court reporter was, and you all can get the transcripts from them. I'm only giving you 30 days. It shouldn't take that long to get the transcript. If it was a sentencing, then usually those are 2 pages of testimony. Anything else?
I believe it was actually at the plea, and we have no idea how long it went. I've never seen this in a state court before, but it is fairly critical. And what my hope is that the state already has this, but this is precisely the type of issue that arose in the Heath case that I mentioned from back in June.
All right,
and what I'd like to do is make sure that we at least
Counsel,
know.
I'm already giving you your motion for continuance.
No, I know. And I don't want to beat a dead horse. And by the
I
way,
mean, that horse is glue.
well, I understand, Your Honor. And by the way, if it's important to you and Richard, I was in Pamplona for San Fermin back in 1965, and it is an exciting time. But in those days, they didn't have the actual bulls that went into the ring. They had older ones that people, even like little Jewish boys like me, could outrun. That's not true anymore. I would say that my hope is, and what we'll need to do is the state obviously has access to this information, and they've been very cooperative. I just want to make sure that we do get that transcript and we get it
Here's
as
the thing. I'm giving you all this specific time, and this is the only specific time you're receiving. So today, you all need to find out who that court reporter is and ask them for that record. And since it is I know that some attorneys may go on and on. They get paid by the word with Charles Dickens. So I don't know what happened during that sentencing.
it was a plea, Your Honor.
Yeah.
Yes.
All right. So that shouldn't take that long unless the attorneys who were on it decided to get paid by the word.
No, Your Honor, the only thing that we've laid out that I anticipate could take long is the production of this phone dump, because.
No, I'm only giving you all 30 days. That's all you're receiving.
Yes, Your Honor. And so to that end, know that we're going to work diligently to process everything that's been produced in that phone dump. But a cell phone dump is typically, terabytes of data.
I'm only giving you all 30 days because let me just tell you, I don't know if you all remember, but this case has been on the docket since 2019. And if you want to say that's juvenile, fine. But it has been in this court since 2023. A phone dump does not take 2 years for people to go through unless they're doing other things, which I understand. Defense attorneys, I
No,
understand.
Your Honor,
how
you don't
have other
understand. We
things to
got
do.
it. We got it on the 24th of January, 2025. That's what I'm saying.
We
The
just
state-
got it, Your Honor.
And so the problem
Well, I
we
have
face
no,
is,
this is what I don't know. I want to know why you're just receiving it then. That's my question. But
That's-
everybody agreed that everybody had everything.
Judge,
That's the point.
just to address the phone dump, it is a phone dump that was given previously. It is just that the certain things that were on our end on Veripic, I don't know how e-discovery, but obviously I don't know if they have access to e-discovery. Was like certain JPEGs or something weren't being able to be opened because of however it got transferred. So that it is the original dump of that phone. It's just that certain pictures and stuff weren't able to be opened.
Now we can use it, understand it, and hear it and see it. And we weren't able to do that in the form that it was previously given, Your Honor. And may I ask a personal issue on the date of a month? Can we start on Monday, the 10th, Your Honor? I'm in federal court the week before that.
All right, Norma, will you set this the first week in April? This is going to trial.
April.
Yes.
Your Honor, I just want to clarify that something for the purposes of the record on this discussion about the phone dump. The defense's position as to the previous version of the phone dump was that because it didn't have a whole lot of recoverable information on it, and there were lots of images that were not available for use, the state couldn't make use of it any more than the defense could, and that may be to our advantage. So we have to now go through this material for the first time that was not accessible in the original dump. I'm letting the court know this, understanding the court's ruling, and understanding the court's urgency to get the matter tried, because obviously we are going to have to document our due diligence and our efforts with respect to it, and we will update the court as that progresses. But I also want the court to keep in mind, as Mr. Goldstein mentioned earlier on some of these other matters, that one of the remedies the court could entertain is an exclusion of that evidence as being untimely.
This is what we're going to do. Motion for continuance is granted. Norma, set this, since you're taking a while, set this for jury selection is going to take place on March 31st. No problem. March 31st, jury selection. There will be no further continuances without good cause.
Thank you for your consideration and your patience.
You're welcome. All right, anything else?
Not from the state, Your Honor.
Not from the defense.
Thank you.
May I just inquire, is it my understanding that that Joanna's plea transcript, that we don't know if there is one? I mean, we know that she testified. Is the state aware that a transcript has been made?
I have no idea.
The state, no, Mr. Goldstein, my understanding is I got all my information from Mr. Hunter. So.
Thank you.
I have no knowledge of whether a transcript has already been prepared. I gather based on the circumstances, it has not, and we're gonna have to find the reporter and request the transcript to be generated.
Thank you.
Is there anything else?
Nothing from the state.
Nothing
Thank
for the
you.
defense.
Thank you, Your Honor.
You're welcome.
May we be excused?
Tamar McIntyre, known professionally as Tay-K, has an estimated net worth of $2.5 million, as reported by the Success Bug. Born on June 16, 2000, in Long Beach, California, McIntyre faced a challenging childhood, as his father was incarcerated during his early years. When he was 8, his mother relocated him and his sister to Las Vegas, Nevada. 2 years later, after his father's release, the family moved to Arlington, Texas, in search of a better life. McIntyre attended Martin High School but dropped out in his freshman year. Influenced by artists like Chief Keef, Eazy-E, Young Pappy, Lud Foe, and his favorite rapper, Soulja Boy, he began to explore his passion for music. On June 30, 2017, the same day his breakout track, The Race, was released, McIntyre was captured by U.S. Marshals after evading authorities for 3 months. Following his arrest and transport to Texas, he garnered significant support from fans online. While incarcerated at Tarrant County Jail in Fort Worth, his management team released his debut mixtape, Santana World, 2017, which received generally positive reviews and made it onto the Billboard 200. In July 2019, McIntyre was convicted of murder in connection with a 2016 home invasion and robbery that resulted in the death of 21-year-old Ethan Walker, leading to a 55-year prison sentence. In November 2019, he was indicted on a second murder charge for allegedly shooting 23-year-old Mark Anthony Saldivar, and he is currently awaiting trial for that offense. McIntyre began his rap career in 2014 as a member of the group Daytona Boys, alongside rappers Pimpaz and Santana Sage. They released their first track, Drift, on SoundCloud on December 25, 2014. Despite their efforts to gain traction in the local rap scene through performances at various parties, the group struggled to attract significant attention initially. Tamar McIntyre, better known as Tay-K, made his solo debut in August 2015 with the release of Biff Zanin on SoundCloud. This track, along with Sly Cooper, released in September 2015, helped him gain local recognition within the Arlington rap scene. On March 16, 2016, he dropped Megaman, which, along with several other tracks, gained further popularity after his arrest on capital murder charges. While evading authorities, McIntyre continued to produce music, including the well-known track, The Race, recorded during his time in New Jersey. The music video for The Race was released on YouTube the same day he was captured. Thanks to a significant hashtag campaign, #FreeTake, the song debuted at number 70 on the US Billboard Hot 100, eventually peaking at 44 and accumulating over 246 million views. The Race has been remixed by various artists, including Tyga, Lil Yachty, YBN Namir, Fetty Wap, and Rico Nasty. During his incarceration, McIntyre released the mixtape Santana World. On September 14, 2017, World Star Hip Hop released the track Coolin', although McIntyre's team later stated that it was an unofficial leak. On December 14, 2017, Santana World was re-released under 88 Classic and RCA Records, featuring a remix of The Race with contributions from rappers 21 Savage and Young Nudy. The track received platinum certification from the RIAA in January 2018. On February 2, 2018, McIntyre's Twitter account shared photos of him for the first time since May 2017, and the following day, he released After You on SoundCloud. In March 2018, reports indicated that McIntyre had earned approximately $600,000 to $700,000 through his record deal with 88 Classic and RCA Records. He made an appearance on the No Jumper label's track Hard alongside Blockboy JB, which reached number 14 on the Bubbling Under Hot 100 chart. He was also featured on the shortlist for the 2018 XXL Freshman list. On November 23, 2019, a family member took control of McIntyre's Twitter account, contrary to the wishes of his manager, Ezra Averill. The family member tweeted various statements expressing dissatisfaction with McIntyre's contract and communication with Averill, promising to help share the truth about McIntyre's life. The tweets conveyed regret for allowing management to control his narrative and emphasized that he was not the monster the media portrayed him to be. In 2023, McIntyre took to X, formerly Twitter, to express his feelings about his lengthy sentence, stating he believed he would have received different treatment if he were a white kid. He reflected on the disparities in sentencing compared to one of his co-defendants, a white girl who received probation while he was sentenced to 55 years for his alleged minimal role. That same year, he wrote an emotional letter to his fans on Instagram, explaining that he was sentenced as an adult for a crime in which he was not the shooter and had no gum. He expressed gratitude to his supporters and shared his commitment to using his music success to positively impact other young artists. McIntyre's legal troubles began on January 1, 2016, when he was in a car with Eric Santana Sage Johnson, who fatally shot a University of North Texas student, Sarah Muchlechner, during a confrontation. Although witnesses claimed McIntyre's group was involved in the altercation, he was not charged in the case. In July 2016, McIntyre was arrested alongside 6 others on capital murder charges related to a home invasion that resulted in the death of Ethan Walker in Mansfield, Texas. The incident arose from a conspiracy to rob a teenager, which led to a violent confrontation. During an interrogation, McIntyre admitted his involvement in the robbery. In July 2017, he was transferred to an adult jail, and a hearing was held to determine his status as a juvenile. Despite the optimism expressed by his attorney, McIntyre was ultimately tried as an adult. Over the following year, several of his co-defendants received various sentences for their roles in the crime. On July 15, 2019, McIntyre pleaded guilty to 2 counts of aggravated robbery related to the home invasion. He was found guilty of murder and a 3rd count of aggravated robbery just days later. His song, The Race, written during his time on the run, was introduced as evidence during sentencing. Ultimately, he was sentenced to 55 years for murder, 30 years for 1 count of aggravated robbery, and 26 years for the other counts, all to be served concurrently, with the possibility of parole after 28 years. After cutting off his ankle monitor in March 2017, McIntyre fled and recorded The Race, detailing his evasion from law enforcement. He was captured by the U.S. Marshals Service on June 30, 2017, after claiming to have swallowed pills and subsequently being evaluated in a psychiatric ward. While on the run, McIntyre was also involved in a robbery in San Antonio, where he allegedly shot and killed Mark Anthony Saldiva. He faced further charges related to this incident, and after being extradited to Behar County Jail, he was indicted for capital murder. While in jail, McIntyre faced additional charges for possessing a prohibited item after a mobile phone was found hidden during a search. He was moved to a maximum security facility and spent significant time in solitary confinement due to behavioral issues. In May 2018, Tay-K's management team claimed that his music was removed from Spotify's playlists as part of the platform's hate content and hateful conduct policy. This drew criticism, and the CEO of Spotify later admitted that the policy was mishandled. Despite this, Tay-K's music remained unavailable on the platform, while other controversial artists had their music restored. Tamar McIntyre has been involved in 3 lawsuits stemming from his alleged involvement in the murders of Mark Saldivar and Ethan Walker, as well as the attempted murder of Zachary Belote and the robbery and assault of Skip Pepe. In June 2018, the family of Saldivar, the victim of the San Antonio shooting, filed a wrongful death lawsuit seeking over $1 million in damages. The following month, Walker's family and survivor Zachary Belote jointly sued McIntyre and his former record labels, 88 Classic and RCA Records, seeking profits from his music following Walker's death and Belote's injuries. On May 2, 2019, Skip Pepe and his wife filed a lawsuit against McIntyre, his former manager Ezra Averill, and the labels 88 Classic and RCA Records. According to Pepe's attorney, these defendants chose to financially profit from McIntyre's violent crimes and take money for themselves from the sale of his music that otherwise would be available to compensate McIntyre's victims. As of 2023, the outcome of this lawsuit remains unknown.